As we begin to discuss the lease, I think it's again fun to go back and see some of the historical reasons that shape the way things are the way they are. Way back in 1853, which if you think about it was about 6 years before the first productive oil well was drilled, there was a lot of litigation about how long the lease would be involving mining. And 5 years was what emerged from this long discussion. And that's interesting because it says it's not 20 years, it's not 10 years, it's not 50 years. So 5 years. And even though today the typical term of the primary term is 3 years, you can see it hasn't changed very much. And then as oil and gas operations got underway, there became the issue of, well, who owns the oil and when do they own the oil? We've already talked about in the class the idea of the rule of capture, that the person who brings the oil to the surface is the owner of it. And whether it's migrating underneath the surface doesn't matter. And then the offset drilling rule says if you think somebody else is draining the oil off of your property, then you have to drill a well and drain it yourself. And so this created the waste that we talked about with the black giant when we saw some of those photos where all the rigs are stacked so close together. And it didn't just happen in the black giant, it was just up to that time. And because of the black giant, we've already talked about pro-rationing, but also what they started to do was put in restrictions as to how close the wells could be to one another. And those exist to this day, and we'll talk about that later on. But pretty significant move where people were forced to spread out. And the last little bit of history I want to tell you about is a very traditional form of oil and gas lease is called a producer's 88 or a special 88. The history of that is that a printer in Oklahoma numbered all of the forms that they printed. Someone brought to them an oil and gas lease, and it just happened to be form number 88. And so they produced form number 88, oil and gas lease. So there's nothing special around the term 88. And I doubt if this is true today, but allegedly people would like, well, what oil and gas lease do you offer? Are you offering me an 88? And so they thought that 88 implied standard and it was a good lease. In fact, none of that's true. Every lease can be negotiated independently. The language of leasing can get a little bit confusing, and so it's important that we understand the terms. So the lawyers like to talk about fee simple property. Simply means you have the right to use the wealth afforded by the land. And the lease is the agreement between the mineral owner and the exploration and production company, or the oil and gas company, whichever term we want to use. Now the lessor is the mineral right owner. So the lessor is the person granting the lease. In this case, the lessee is the oil and gas company or the person being granted the lease. Consideration is what the lessee is paying the lessor to establish the lease. Legally, in some states, the fact that consideration is paid is important. They talk about in the textbook that often the amount of the consideration is not disclosed because it becomes a matter of competitive advantage, and oil and gas companies would prefer not to talk about how much they're having to pay. In addition to the consideration is the royalty, and that is a percentage of the production that is given to the lessor for granting the lessee the right to drill and produce those minerals. And then the lessee has 100% of the working interest. And so you'll see working interest a lot in the discussions. In many cases, you'll see WI abbreviated, that stands for working interest. And the reason that becomes important is it's possible where the operator has perhaps the majority working interest or the largest working interest, but lots of other people are also investing in that well, and so they also have part of the working interest. I've already tipped my hand a little bit on this, but what law applies to this? Well, leases are contracts, and for the most part, contract law in the United States is state law. Therefore, there can be significant variations between states as to the particulars of oil and gas leases. Oklahoma has different laws than has Texas, and because Louisiana is based on the Napoleonic tradition, they have very different laws for oil and gas leasing as well. And so when you talk with an attorney about an oil and gas lease, you have to make sure that they're quoting you the rules in that state. Although some issues perhaps bubble up to the federal issue. We've already talked about in the class that it's possible to sever the surface rights from the mineral rights. So the surface owner does not always control the minerals. Now, given that, and given that we have to operate from the surface to drill into the minerals, can the surface right owner effectively block the mineral right owner from leasing the minerals? And the answer is no. The mineral estate is considered the dominant estate. And so what rights does the surface owner have? Not nearly as much as you would think. They can't tell the person they can't come on the land, and every landman who's got decades of experience will talk about being chased off of a land by somebody with a shotgun or prevented going onto land with somebody with a shotgun. These are the surface rights owners who are not happy because not only can you drill, you can do things like put tank batteries, build roads. So the surface right owner is sacrificing some. Now there is a term of reasonableness, which again becomes a legal interpretation issue. As you go into the lease, it's important to think about what does each side want? Well, what does a lessor want? A lessor probably wants as much money as quickly as they can. So they like larger acreage bonuses in terms of consideration. And typically that's what you get is you get a paid amount per acreage, and we'll talk about that more in the consideration. So they would like more money up front. They also want to make sure that the oil and gas owner, the oil and gas company is motivated to produce the minerals as efficiently, as effectively as possible. For the most part, you would assume that they would also want them produced as quickly as possible. All this makes sense. Particularly if they're the surface rights owners, they want as little environmental impact on the surface as possible, or even if they just know the surface right owner, they may be particularly sensitive to that. What does the oil and gas company want as the lessee? They want a lot of the same things, but there are some subtle differences. And I would say the number one thing they want is they want flexibility. They want to be able to drill that well when it makes sense to them, and they want to produce at a rate that makes sense to them. You would think they would want to drill it out as quickly as possible, but financially the oil and gas company might not be able to afford that. And so they might have a much slower development time frame for the property than the lessor might want. And so flexibility is something that they really want. And we'll talk about in the wrap up how the nature of the lease can sometimes affect what oil and gas companies choose to do. So the first question is who owns the minerals? And this is the first task for the landman, is to determine who in fact is the mineral right owners. 100 years ago, that was probably a lot more straightforward than it is today. It's not uncommon when you go into the inverse logs on a well, you can actually see who's getting paid royalties. And I've seen wells with over 100 names on them, which is to say there's over 100 people that there is a signatory to that lease to draw royalty from the drilling of that well. And so how does the landman do that? Well, they start with trying to find who initially owned it back when it became first transferred from the state to an individual, and then tracking it, and that's what a run sheet is for. They use all the records that you see indicated on the chart. Once upon a time, it involved going to courthouses. Now, for the most part, those records are available online. If you pay for some of the higher subscription levels in Inverse, it'll actually have a lot of that stuff, the court records, online. Sometimes there are gaps in the title or uncertainties in the title, and addressing that problem is called curing the title. A lot of very detailed, tedious work, and it culminates with a title opinion that says basically, where a lawyer signs off, this is who in fact has mineral rights to this area that you want to drill. Huge, huge problem if an oil and gas company drills a well and somebody pops up on the radar and says, oh, by the way, I also am a mineral rights owner there and you are producing. And that can cause problems if you've got to cut somebody else in on the payments. It can cause problems if I didn't give you the rights. huge problems. And so because of that, they're very careful in trying to positively ascertain what happened or who owns the mineral rights and getting a lease with all of the proper people before they begin to drill. In the next video, let's talk about some of the specifics of the lease.